Good afternoon, viewers. I'm Usman Ghani from Ammanah Legal, and I'm present today with Mr. Asad Hussain Rana, who is a principal lawyer at Ammanah Legal. Viewers, welcome to our video. Today, we are going to discuss a recent migration matter. This was a administrative appeal tribunal where Amana Legal actually acted for the applicant and saved his visa cancellation. I've got a few questions and I would like to put in front of Mr. Rana. Welcome, Mr. Rana. How are you today?
Yeah, very well, thank you. And thank you, Usman, for organizing this. So, very briefly, we work together, obviously, and Mr. Usman Ghani has been instrumental in developing this platform where we're going to now start communicating with people and making them aware of their rights and remedies, if you like, or reliefs under law. Our objective is obviously to make law very easy for everyone, so it's understandable and people know what their rights are. Over to you, Usman.
Mr. Rana, that was very interesting case for me, and actually under your supervision, I have learned a lot in this administrative appeal tribunal. The citation I would like to give it to the viewers as well. It's a AAT 2020/7839. Viewers, I wanted to tell you a little bit more about this case. This was a migration matter where a permanent resident visa was going to be cancelled. A client approached to us and we did his submission. We appeared in the appeal tribunal. In fact, Mr. Rana was our team leader there, and we definitely got a very extraordinary outcome from there. Now, I will put some question in front of Mr. Rana. Mr. Rana, can you just advise us and advise to the viewers what was that case about actually?
Right. So we had a client whose visa was cancelled. Now he was on a permanent sort of visa, such a New Zealand visa, which is subcategory of 444, special category visa, and he has been living in Australia since he was about 80 years old. And at the time of the application, he was about 34 years old. And yeah, so his visa was cancelled on character grounds, also referred to as, legally referred as Section 501 grounds, where there is either, considerable or substantive criminal history, for instance, or there are other character issues that the department takes into account or the minister takes into account. And then depending on the person's character, they can cancel someone's visa. So it was basically character ground cancellation, if you like. The procedure was nearly met by the Minister for Immigration. However, there was an aspect of it which we'll discuss down the track, a warning aspect that was missing. And the visa was cancelled. There was obviously a national justice letter issued, and then there were submissions made. The department did not consider those properly and did not have proper regard to them, because of which the visa was ultimately cancelled. So we had to apply to a tribunal or administrative appeals tribunal. Now, tribunal has a set number of days to decide on these applications. They're fairly quick. Other migration review applications can take, for example, years at the moment as the status quo stands. However, for this particular application, there is a time limit set for about a couple of months to just pack it up and get it going. So it was a fairly quick application, and we attended a hearing. I was in front of a senior member at the tribunal. We made submissions, cross-examinations, and all the rest of it. The department was represented by a barrister or a counsel, and ultimately the matter was decided in favor of our client, and obviously he got his visa back and the cancellation was revoked.
Mr. Rana, thanks for a brief explanation to this question. I've got a next question. This client had a very brief criminal history as well of over 10 years. What factor and how did you manage that part of and was able to convince the members of the AAT on that? Could you please put some lights on that as well?
Yeah, so for our client, it's quite extensive, as a matter of fact, the criminal history. It spanned from the time when he was quite young, from his teenage years, and there was a gap, bit of gap, I think about 4 years gap in between, but largely since his age of around 15 years onwards till about 28, 29 years old, there was quite extensive criminal history. So number of charges, and he pleaded guilty. He's served obviously a jail time. And one of the requirements, if under the cancellation of this visa and the ministerial direction that we'll discuss later, one of the factors is that a person would have served a 12 months imprisonment sentence. If that happens, then in that case, Department of Immigration, either the minister himself or by delegate, can cancel someone's visa. So yes, there's extensive criminal history ranging of different type of charges, from assault to to recklessly causing injuries and whatnot. So ultimately, he had spent his time in jail, and while he was in prison, his visa was cancelled. Yes.
Yeah, as you just said before, ministerial direction. I've got a one question regarding that. So, in terms of the relevant factors under the ministerial direction issued and under Section 499 of Section 499 of the Migration Act, what are the implication of the absence of a warning as to the cancellation of the visa for this client? How did you deal that?
Yeah. So look, I mean, the absence. So basically, a visa holder needs to be put on a warning, some sort of a warning, if there is a pending cancellation for that visa applicant. So the whole regime is built around if you like, the cancellation regime is built around these these steps that needs to be taken. And if the steps are not missing, then we can say there is a procedural irregularity, if you like. So in our case, for instance, I mean, there was a natural justice letter provided to our client, and like I said, submissions were made. However, in relation to his visa itself, or the cancellation itself in the first place, there was no adequate warning. As a matter of fact, there was no warning at all. So in his visa, for instance, he made some representations in filling out his passenger card. He was not warned in that aspect that, what can be the consequences, for instance, of filling out a card incorrectly, or as it was alleged, that intentionally he did not disclose his criminal outcomes or his criminal history, if you like. So yes, there needs to be a warning given before the cancellation occurs, but there's also the warning implications with other procedures. For instance, if the department or minister needs to rely on a certain document that is produced, then whether there was adequate warning, or whether there was warning itself in the first place given as to the content of that evidence. And that is important as well, because everyone does not or cannot foresee, for example, what is going to happen if I answer one of the questions in passenger card wrong. So that was the issue there with the warning.
All right. Okay. Mr. Rana, I've got just one question came up. What does someone means a product of Australia? Can you just please put us some light on that?
Yeah. So product of Australia. In this case, it was relevant, and product of Australia simply means that someone who is either born in Australia or at the minimum bred in Australia. So that, for example, in this case, with our client, he was about 8 years old when he came to Australia, I said, from New Zealand. So he spent a considerable part of his life in Australia. So to say that, look, we're going to kick him out, because he's got another nationality, for instance. Our argument was this is prejudice, because all his life he's been raised in this culture and this society. And if he is actually a product of this society because of the time he has spent in his adolescence and then moving forward to his teenage years and then onwards to his youth. Um, Therefore, a person who is part of this society is a product of Australia. And as you can imagine, any manufacturer of a product should take responsibility for the product. So it's not a very clear matter of you've come, from a different country, for instance, and you've had the previous criminal history there, and now you have criminal history here, and all that sort of thing. It needs to be distinguished by someone, for example, for instance, for someone who hasn't had a previous criminal history. Or what criminal history are you going to have when you were 8 years old? But then you're raised in this system, and then certain things happened and got you off the track, bad company, whatever it is. So you become product of that country where you're raised. Yes.
I see. Mr. Anna, I've got a next question for you. It's regarding the Ministerial Direction 79. What is the person's nature in seriousness of the conduct under para 13.1.1 of the Ministerial Direction 79? Can you please explain a little bit to us?
Yeah. So look, Ministerial Direction 79. It's obviously a direction by the minister, and the minister is able to make that direction because of the operation of Section 499 of the Migration Act, which empowers the department, the minister, to make these directions. So this whole visa cancellation regime, if you like, is brought under this. Part of that was Section 501, but brought under this regime of the minister. So minister directs, okay, these are the factors that need to be considered before visa cancellation can be eventuated, but also these are the primary considerations that need to be taken into account when someone's visa is going to be cancelled. Now, under this direction, there are about 3 primary considerations, and then there are some additional matters, or also referred to as other considerations. The primary consideration are obviously protection of Australian community from harm. When someone has got a bad character, or if you've got criminal history and that sort of thing, then the community needs to be protected. That's obviously the first primary consideration. Then the best interest of minor children in Australia. So if someone has got children and this person's visa is cancelled, what are going to be the effects on those children who obviously are Australian citizen or Australian permanent resident? Then what is going to be the effects on their lives if this person's visa is cancelled and is made to leave the country? Then there's also the expectations of the Australian community itself. So, for instance, what does the community expect from a person? Now, again, these matters are already well established. Some of these matters, actually most of these, but all 3 of these are well established by a number of case law where I can cite a few as we keep on going. But a number of cases have been decided where these terms have been defined, the considerations themselves have been thoroughly interpreted by the court. So, and the court of law in this regard being federal courts or the tribunals. Previous decisions also referred to as precedents. So in very simple English, I'm trying to keep it as simple as I can. But look, there are 3 considerations, primary considerations that the visa, the person who's making determination on a visa, whether it's a delegate of the minister or the minister, they must keep into account. And then there are obviously additional matters or additional considerations, and those are, for example, international. If you've got a non-refoulement obligation with someone, if you've got the strength and nature and duration of facts, and I'm just going to read the other. There's about 5 of those. So, impact on Australian business interests, then impacts on victims, and extent of impediments if removed. So there are about 5 different other considerations that need to be considered as well. So our case primarily for our client was to show that, look, these 3 primary considerations and the 5 additional considerations, we had to establish that the weight on these considerations was more heavier on our client's side. If the tribunal member was to accept that the weight to be given, or the consideration to be given to these matters were more favorable to our client, then the visa revocation, the cancellation revocation would have been successful. And that's what happened. So the tribunal member considered all the evidence before him, and he said that these matters or these considerations are satisfied more in the favor of the applicant or our client.
Thank you, Mr. Rana. Actually, I do have a couple of more questions, but you have answered regarding the expectation of the Muslim community just here now. Thank you for your time today, and I will definitely will come back with that with any more views. If you have any question, please do not hesitate to contact us regarding if you have any migration matter regarding the same situation we have been dealing. Thank you, everyone, and goodbye.